Mr. Torres.
Mr. Chairman Pierce, again. There's been a lot written about the privacy concerns and those issues, and so I won't dwell on those. I just wanted to note, I think from a more practical perspective, I think within the next 5 to 10 years, requiring the disclosure of email addresses, personal or business, will have as much effect on expanding employees' access as requiring Excelsior lists to be provided on floppy disks. I mean, the rapid pace of technological change and personal communication habits will show us that any purported benefit to be gained by imposing this requirement is far outweighed by the burdens imposed upon employer property rights and employee privacy. The Notice of Proposed Rulemaking notes that there are a few examples of employers who used its property to communicate during a campaign. As Member Johnson noted a moment ago, not all employers elect to invade the province of their employees' workspace in such a fashion. And so it's certainly not a foregone conclusion that it's sort of the Wild West in terms of communications on non-business related matters. It's not even clear, there's no evidence that I've seen here as to how many employees actually possess work emails. I mean, we're talking about broad ranges of individuals in the service industry and the manufacturing and construction industry, so I'm not even sure that there's any indication that there would be any market benefit by making such a requirement to the extent we're talking about business emails. And third, as I said, employers are migrating to communication systems that discard email and look at text messaging and unified communications that integrate with business information, and so I think there are serious questions about whether the board should be invading the employer's property rights in such a significant fashion, given the numerous other alternatives that unions possess in order to reach out and communicate with employees. On the personal email front, the generation that will be most affected by the regulations that you are considering are stopping to use emails in increasing numbers. They are using social media platforms, Tumblr, Instagram, Facebook, WhatsApp. I suspect that the communication standards that will be most utilized 5 from 10 years from now don't even exist. And so I think that doesn't mean that we sort of broaden this obligation. We just understand and realize that unions have a myriad of avenues by which they can make outreach to employees that don't require us to be burdening employers' property rights or employees' privacy rights by disclosing personal email addresses or Instagram accounts or text messaging accounts. There are countless examples that you can find out there of individuals, political parties, other groups employing inexpensive, sometimes free social media platforms to target and reach very specific audiences. We just heard from Professor Brofenbrenner saying that no union in its right mind would even file a petition unless they had 60 or 70% of the employees signed up on authorization cards. And so I question, given those statistics that presumably the professor has researched, that there's any incremental benefit to be gained here by providing access to this type of information. There was a recent article that I found about workers in China who organized themselves without a labor union using social media and cheap smartphones. I think that the need for this type of additional requirement needs to take into consideration the fact that there is technological advances out there that will continue to evolve that provide direct access to these employees in a manner that allows the employee to evaluate whether it wants to engage in the conversation that is being offered. It doesn't have to be faced with an email in its inbox any more than it has to be faced with someone standing on their front door, any more than it has to be faced with someone ringing their phone. So I would suggest that this proposal doesn't serve any material benefit to the process.
Well, but isn't that the point? Aren't you making the point? Right now, the Excelsior list is the law. There's an obligation to provide a name and address, and knocking on the employee's door unannounced. There's arguments that say that that's an intrusion on privacy.
That's
the law.
That's a fair point, but I could take that same Excelsior list, Google those employees, find their Facebook pages, and send an invitation and ask that employee to accept my invitation to have a conversation. I can send an invitation through their LinkedIn account and ask them to have a conversation. And so I think that's the point. You can take the names of these individuals and through technology outreach them without having to provide their personal email addresses. I don't think that there's any requirement that that is a necessary step in conducting any of these electronic outreach efforts.
Do you think that the employer has a more proprietary interest in having possession of that information than a union would?
To the extent that you're talking about an employer's work email addresses, I do think they have a greater proprietary interest. As to their personal emails, I think it's a question of the terms and conditions under which it was provided. I understand the concern of the woman who was here a moment ago about the employer using their information to text information. Well, I think the question there is, was it provided to them in a circumstance where they understood it would be used for a more limited purpose? If it wasn't, then I agree with you that there may be some questions as to what the scope of the proprietary right really is.
Quick question. Sorry. I think your point about looking at the whole universe of alternative channels makes sense, but one of the comments, I think it was by SEIU, in fact, noted that, for example, if you're going to find Harry Johnson on whatever, Facebook. It's not me, by the way. I don't have a Facebook account.
MySpace.
But, right. Well, basically, you might be looking at 300, 400 people. And so what utility is that going to be if the union doesn't actually get the social media ID?
Actually, I think that's an overstatement of the difficulty. I think if you can throw in someone's name in their city, you can locate I realize there may be the Sam Jones and the Harry Johnsons out there, but there certainly are innumerable other individuals whose personal identification information is
There are
easy.
Joseph Torres is out there, too.
Well, don't go to Mexico because you'll never find him.
All right.
I don't think you could find any of those things for me. But do you think then that the if the union's opportunity to inform employees, which seems to be the word for today, was to ask the employee if they wanted to be so contacted, that the employer should have that same a similar sort of opt-in? In other words, if the employer was having a meeting, if the employer was sending an email, sending a text message, giving a piece of literature, the employer could turn all of that down and say, I don't want any of that anymore?
Well, again, as I think Member Johnson said, we're not talking about an equilibrium of standards here. Well,
Okay.
that's the differential here, I think.
Thank you.